The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
You may be seated. Good morning. We have 3 cases for submission this morning. The first case is State of Iowa versus Leedom. The second case is Rowland versus Annette Holdings. And the third case is State of Iowa versus Ververka. We will take a short recess between the second and third case, probably for 5 minutes. So we're ready for the first argument. And Mr. Brown? Sorry, Mr. Montgomery.
May it please the court. Your honors, counsel. Rob Montgomery, along with my colleague Brandon Brown, for Mr. Leedom. Your honors, Mr. Leedom is incarcerated because of this offense. However, his wife Susan and his brother Ed are here today. Your honors, this charge and the conviction arising from it arises solely and exclusively from the oral testimonial accusations which a teenage girl who wanted to live with her dad made against her maternal grandfather, Mr. Leedom, during the heat of a bitter custody dispute over which household she would live in, her mother's or her father's. It is uncontroverted in the record that this teenage accuser, H.M., admittedly, boldly, brazenly lied to the DHS about the factual circumstances surrounding this custody dispute in order to make it easier for her to get what she wanted in that dispute. That was to live at her dad's house instead of at her mother's house, the daughter of Mr. Leedom. It is also uncontroverted in the record that in addition to it admittedly lying to the DHS, that H.M. admittedly lied under oath during the depositions in this case, which lies were to cover up for her father's dangerous criminal acts, which were harmful to her, H.M., his teenage daughter, and which lies were designed so H.M. could get what she wanted living with her dad.
So this case involves a he said, she said dispute where her credibility is at issue. Should the district court have done the ex parte examination? Is impeachment alone sufficient to get access to her mental health records?
For Mr. Leedom, Your Honor, this impeachment is sufficient to be exculpatory. The broader question of is all impeachment sufficient to be exculpatory is different. We would like this court to adopt the approach from Barrett and Rederath, but for Mr. Leedom's remedy, we asked the court to find on the case-by-case analysis, in this case, that this impeachment is sufficient to be exculpatory. Yes, we think the court, Your Honor, you asked about ex parte, which would be ahead of in camera. And we asked for ex parte pursuant to State v. Dahl, which was...
But wasn't State v. Dahl more about the plan of the defense, their theory of the case?
Yes.
Isn't there quite a difference between what you're asking for and what Dahl was about?
With respect, Your Honor, not as much as the court's question might suggest. They were 2 statutes, and they were statutes where, to comply with the requirements of the statute, defense counsel on behalf of an accused has to come in and make a showing to the court in order to get what the statute provides for. In Dahl, it was concluded that that shouldn't infringe on their right to effective assistance of counsel and a fair trial by having to tip their hat. With respect to the court, I would say this is a stronger case for an ex parte hearing because we're talking about cross-examination and trial strategy specifically.
Yeah, but I mean, the difference is in Dahl, the only interest of the state is really, the only countervailing interest of the state is really saving money. I mean, that's their interest. And, you know, my spouse says I'm a natural-born judge because I'm cheap. Judges are capable of, I think, protecting that interest. The prosecutor, one could argue, is needed in the context of a cash-in type situation because the prosecutor is going to protect the interests of the alleged victim. Isn't that a difference?
We believe, Your Honor, it should be a twofold bifurcated proceeding. So much like I believe in Dahl, it started out of the gates at the threshold with the prosecutor present. The prosecutor is entitled to file a resistance and appear, but when it comes down to the nuts and the bolts, tell us exactly why in this case with this defendant you need this investigator to look at this witness, the tipping of the hat. Now, I would concede, Your Honor, that the other side, the state's interest in saving money, is not as strong and as powerful as protecting confidentiality. We concede that. However, the defendant's interest in protecting not having to tip your hat is stronger. And I don't know that it was driven by the flip side of that coin being the money. I think it was driven by the other side, which was we don't want to make defendants have to tip their hat. In this case, what is lost if the court, for example, in the Thompson case, in Thompson, the court recognized that we've got to follow the legislature's intent that this be reviewed by judges alone without defense counsel there. That was the legislative's intent. We are not asking to undercut that at all. In Barrett, the Court of Appeals suggested maybe the legislature should consider amending. However, one way to do it under the current statute without amending is ex parte staying, as it rightly should, with a review, in camera staying with a review by the judge, but ex parte happening after the dual representation, and then the defense attorney enlightening the district court judge and educating the district court judge prior to the review so the judge knows what he or she is looking for. That way, the review itself is still just done by a district court judge, which we have every faith will do it the right way, but it's done by the judge alone, but educated, and it still protects the right of the individual whose records are being reviewed.
Let me try a narrower proposition, and I want you to push back if I'm too narrow. But so you have HM saying something to the effect that I did tell Jessica about the sexual abuse, or words to that effect, and you want to impeach her. What would be wrong with having the court do a in-camera inspection on that narrow issue? Namely, is there anything in the record to suggest that Jessica was told? If the answer is it's in the record, you're done. You don't have impeachment. If the answer is it's not,
mostly on that, Your Honor.
Yeah. Well, I mean, both sides sometimes go for the home run ball, and I'm kind of trying to narrow down this dispute a little bit. It seems to me, to the extent you want to impeach potentially this HM, I see the impeachment. I can see how it might be pretty good. But if the record doesn't support it, you're done on that ground at least. And if there's nothing in the record, then maybe you're entitled to establish that. So what's wrong with my line of thinking?
Nothing is wrong with the court's line of thinking. The suggestion that if something about the accusation is in the record, that's the end of the flow chart, is a little too
Judge, I'll
is a
tell
little
you-
too simple because, for example, if there was first of all, it's with respect to the state, it's ludicrous to think under the extensive offer of proof record in this case that it's going to be in there. The therapist already testified that if one of my patients gives this to me, I write it down and I put it in there. If it's a person under the 18 that makes a report like that, I write it down and I put it in there.
Okay, but my point is this. Supposing there's 50 pages of records. I'm just pulling this out. It could be 100, whatever. There's 50 pages of mental health records. It seems to me you may have made a foundation for this impeachment line. I'm not sure it's a strategy that everybody doesn't know. It seems to me it isn't that hard for the court to go through 50 pages and determine whether there's, kind of impeachment material on that point.
Particularly if we've narrowed it down in an ex parte hearing for the court before the court does it.
I'm not sure you need the ex parte hearing, is what I'm saying. I know. I think I know. You want to impeach this witness, and you've impeached her on some other points, and you want to zero in on what you think might be a really nice addition to the impeachment. Why do we need an ex parte hearing on that?
Well, perhaps on this record, it's sufficient enough in looking back in hindsight that we've got enough without an ex parte record. We went ahead and did some spilling after we didn't get the ex parte record, which was unfair, but we didn't know whether the court would track State v. Dahl in this case, so we wanted to put up the best fight we could at the district court level. If it's absent from the records, and by the way, I think it's the Edward case talked about the absence of something from the records can be sufficient to be exculpatory. That's
Sure,
where the minister and the sexual assault.
But I don't mean to argue, prolong it, and I'm sorry if I am, but if a judge looks at it and says, you know what, I understand you want to impeach her on this business. I did tell Jessica. I reviewed the records, and there's no basis for impeachment. Because I reviewed the record, and in fact, there's no impeachment material here, period. I mean, it seems to me that would be adequate. On the other hand, if it turns out that there's nothing in the record on it, then the court says, I've examined the records, and counsel, you're right. There's no mention of sexual abuse in the notes, and you're entitled to establish that fact.
Yes.
But what you're not entitled to do is to drive your dune buggy over 100 pages of mental health records looking for interesting bones.
We agree, Your Honor. And it really came down to that one item. And when the court says we were allowed to impeach, this was the one thing where the lie was specifically about the specific criminal accusation, where some other impeachments were collateral. This would have been a non-collateral impeachment on the actual accusation. And so strongly, so the second question would be end of flow chart. The first one, I feel so strongly, and under your question, Your Honor, that we think it would be appropriate for this court to direct the district court, when you do this quick review and you find no mention of it in there, we direct you that that's exculpatory under this record and these facts. Now, it would still be for the district court to decide whether or not a new trial should be granted, but the absence of it is extremely exculpatory.
I want to challenge you a little bit on that, on a couple things. Number one, you've used that word lie a lot. Isn't it also very common to consider that recanting? You've been saying this girl's been lying here. I think you used that word 3 times in your introduction. But isn't it very common in a sex abuse case for there to be A, B, back to A, maybe a little bit of B? Isn't that a common scenario in sex abuse cases?
Recanting on what happened to me and what happened, this is quite unique. Your question is appreciated, Your Honor, but this is quite unique. It would be, I don't see a lot of recantation of I told my therapist. And I don't see a lot of recantation of, I told my therapist about Grandpa Rick Leedom and...
But it is a recanting of that sex abuse ever occurred. You're saying that she said it happened, and then later she said it didn't. Isn't that what the record shows?
No, I'm not saying the impeachment, Your Honor, is... So
I understand the impeachment of the records. I understand what you're getting at. She said she told her therapist, and you're believing that's not going to be in the record or in the therapist's notes. I understand that. But that the allegation even occurred...
We're not in any way suggesting she ever recanted that. She has stood on the allegation. Our theory of the case, once the charges came as a result of the allegation, was that she did this only after this big debacle with her dad getting in the car crash.
I understand that, and the divorce or whatever the custody case was.
And that she created this, I told my therapist years ago, to undercut that by saying, I just didn't do it right after the debacle.
So she's been consistent that it happened. What you're getting at is that she said she told a particular person and she may not have. Is that correct?
Yeah, she almost certainly...
But the bottom line of the incident, you do acknowledge she has not varied from that.
Well, we don't suggest she's recanted it.
That's what I wanted to get. Thank you.
We don't suggest she's recanted it. Thank you, Your Honor.
Thank you. Mr. Mullins?
May it please the Court. There are two principal issues that we believe would benefit from this Court's consideration. The second is this question of vouching by experts, but I would rather devote the bulk of my time to the first issue, and that is whether impeachment is the same thing as exculpatory evidence for purposes of breaching a statutory privilege. And you'll forgive me if I do try to go for the home run ball, but I think that while some impeachment evidence might be exculpatory, not all is. And I think that can be consistent with the legislative intent, which is the governing structure of our consideration, and that is Section 622.10, subparagraph 4. So what did the legislature mean when it said that an in-camera review was required only for exculpatory information or exculpatory evidence?
I mean, I'm not so hung up on the legal categories. I mean, let's talk about the facts. So HM, as I understand it in deposition, testified that she told Ms. Schmidt, the therapist, about the grandfather's abuse. And if we look at and Schmidt's records, and there's no record of that, isn't that something that is going to be pretty significant in terms of helping the defense in this case?
So that is why I think there's an importance to the difference, to establishing a difference between that which is favorable to a defendant but collateral or merely impeaching, and that which extrinsically tends to exonerate the defendant. And that, by the way, is the definition of exculpatory evidence, and one which, although Rederath and Barrett used the shorter version of the definition of the two, I think the fuller definition of that term, particularly knowing that the legislature has used impeachment in a different portion of Chapter 622. I think what I would say is that while I can agree that would be impeachment evidence, because it does not extrinsically tend to exonerate the defendant. It's not as if she was saying or did say to the therapist, I hope to falsely accuse my grandfather because I'm mad at my mother.
I know, but normally when we think of impeachment, we think of an inconsistent statement on something other than the central issue in the case. Here, the central issue in the case is whether she was abused or not. So saying that she told her therapist, if the records show she didn't tell the therapist, it seems to me it could be both impeachment and exculpatory, right?
I'm not prepared to concede that it would necessarily be exculpatory. As the district court concluded, it determined that, well, that in fact could be true, that she was speaking falsely or exaggerating in the deposition, and she just didn't tell her therapist earlier on. And so that, in the district court's
As I understand, the story went beyond that. It was also, she told the therapist and made a pact with the therapist that the therapist wouldn't tell anybody else.
Sure.
So, at this point, if I'm representing Leedom, this is something I think I'd really want to present to the jury and let them make up their mind, right?
Well, and I have no difficulty with the notion that this would be something that any given defense attorney might want to use for the reasons that you had expressed. However, and this is a minor point, I don't wish to belabor it, but I think the phrase pact might have been a characterization of what occurred. I don't think that's what she said. I think she told the therapist. I told her that I already told someone about it, and incidentally, the therapist had indicated that she might not report it if it had already been taken care of or had already been reported. So, in that instance, the absence of that of a report, for one thing, might not necessarily be as powerful as one might expect. Now, the absence of a notation in the record might be more helpful to a defendant, but again, so long as we're not talking about a recantation, say an affirmative statement where she's saying, no, it did not happen, then I'm not prepared to concede that it rises to the level.
When does impeachment, if ever, rise to exculpatory under your view?
It would be, so anytime you, for example, say initially at point 1, my grandfather has never abused me. And then later you say, my grandfather did abuse me. Those are inconsistent statements. And so, by definition, impeachment. But also, I think, would likely rise to the level of exculpatory evidence. Now, if instead...
Isn't this sort of close to that? Because she said, I told the therapist he did abuse me, and if it's not there, it gets pretty close to being a statement admitting that I didn't tell her, inference, he didn't do it.
So I would recognize that it implies that perhaps abuse did not occur if in fact she went there to talk about the abuse. But
more than an implication, it's an inference. I mean, and we allow inferences in circumstantial evidence. People get convicted on circumstantial evidence and inferences without direct evidence.
Sure, and we may be arguing over ever smaller degrees of differences. I'm not prepared to say that an affirmative statement, which is inconsistent, is not exculpatory. I think
I want to talk to you about that. I think good lawyering is, on the prosecution's as well as the defense side, can handle adequately whatever it is the defense counsel. If they're successful in getting something in about whether or not there's a statement there, it's going to require good lawyering on both sides to address that. But I liked Justice Appel's comment about driving a dune buggy over 500 pages of records. Would you be agreeable with some kind of an approach of an in-camera review, and on that limited issue, like Justice Appel talked about, and then let you lawyers talk about it before the jury, I assume if there were a new trial, but you would talk about it before the jury, but some kind of limited review by the court? Because as I tend to disagree with some of the questions by Justice Wiggins regarding that might mean it didn't happen. I've seen too many kids testify about sex abuse, and it's a difficult situation, and their stories are all over the place. So, but I do think whether it's in the record or not is important for the defense to know. So, would you be agreeable with a limited look by the in camera?
So, of undesirable outcomes, I could say yes. But I'm not prepared to acknowledge that it is the safer, easy, or preferable solution. My concern with too easily agreeing with you is that if we consider the context in which 622 came into force, there was a legislative recognition of the importance of this privilege. And if my concern is that over time, perhaps we've become accustomed to this as if not a pleasant alternative, then at least a decent safety release valve that preserves the defendant's, or I'm sorry, the witness's interests in containing their very private thoughts and therapies. And so I think we should continue to bear in mind the the sensitive nature of the conversations that occur between a therapist and
I agree.
patient.
I do. I agree with that. But doesn't this one kind of seem to go just a little bit outside of that? It's more about something she told the therapist. It's not even so much the content, but did she even talk about it at all? It's not even specifics.
Well, and in a way, I do tend to agree, but only so long as we recognize that what we're talking about is impeaching the subsequent statement that she made at a deposition. We're not talking about, I mean, I guess the very best that you could say is that for reasons that perhaps experts will recognize, children might not reveal their information about abuse or might even recant periodically. It might not be surprising then that there would be an absence of that information.
That's why I'm talking about good lawyering. So I'm wondering, is there really a lot of harm, the defense, if they would have that opportunity for the judge to look at it? Couldn't you explain it or have an expert perhaps talk about the statements by children of sex abuse?
And again, I certainly can appreciate the perspective. And if we are only talking about less desirable alternatives once this court has concluded that this matter has to be reviewed in camera, I entirely agree with that. It's not the result that I prefer, and it's not the result, incidentally, that I think the legislature necessarily intended.
I think you're right. If we went that route, it would probably be a conditional affirmance, I suspect, depending on A, what does the record show? And you might conceivably prevail at A, and then B, if it is in there, then there'll have to be consideration of what impact it has on the underlying verdict.
Yes,
Right.
and correct. And if I might, I'd like to do a little bit of tidying of an otherwise necessarily messy and incomprehensible brief that I prepared for the court. I misspoke where I said that if there is exculpatory evidence, then a new trial would be required. And I agree with defense counsel. I think the structure, as Niederbach and Edouard had laid out, that it would go back for review to determine whether there is exculpatory evidence. If there is, it's disclosed, and then if necessary, then the court determines whether a new trial is required. So there are a couple more steps that would have to occur.
Is there a need for an ex parte hearing to determine whether you should have an in-camera look by the court first?
Not at all. I don't think that there's a structure contemplated in this statute. At least in Dahl, the plaintiff there had going for him that the federal analog contemplated an ex parte hearing. I think the equities and the interests are different. The state's interest in providing funds for investigators, some of them were antiseptic. On the other hand, unlike, say, for example, a Brady issue where evidence or interest is in the possession of the state and it's not privileged, this is material that is held by a third party for which there's a rather keen privacy interest. And so I think it would be unfair, and incidentally, I suppose we are talking about the interests of the privilege holder, not necessarily the state. So while oftentimes the state does step in to try to attempt to address some of the privacy interests of the privilege holder.
In this case, there may not be a need for an ex parte hearing because everybody knows what we're looking for or what the defense is looking for. But are there certain cases where there may be a situation where it would disclose defense strategy? And just like in our other cases where an ex parte hearing may be done? I mean, we can't rule it out, I don't think, or can we?
Well, I don't know that the court necessarily needs to express an opinion on that topic here, given that it's not determinative. I'm somewhat uncomfortable with the notion of leaving it open. I tend to back up, as you know I often do. I'll ask first, well, does the Constitution require it? And if the question is simply, is there a constitutional right to maintain a secret strategy through the progression of a case, I think that's a difficult proposition to adhere to. We ask defendants, for example, to provide notice when they're going to use an insanity defense or something like that. But narrowing it down more to the point of whether in any given factual circumstance an ex parte hearing would be required, I'm not prepared to acknowledge or concede that that would necessarily always be true, or that the court, even in its exercise of jurisprudence, ought to say anything about it. For purposes of rendering narrow opinions, I think it wouldn't be necessary.
I have a quick factual question. Am I correct in my review of the record that the state has not been privy to the requested records?
I don't believe so. I know that I haven't. One of the other considerations that drove the necessity for an ex parte hearing really was the question of, it arose in the context of seeking funds, which necessarily implies that you have a defendant who's indigent. And so a lot of what propelled that consideration and the granting of an ex parte hearing was the fact for funds was that that's not something that the better heeled defendants need to do. And so without that, and without the rather antiseptic concern about protecting the public fisc, as weighed against the constitutional interests of the defendant and the victim, I think it's a rabbit hole that we need not go down.
How about on the other issue, the vouching issue? And let me briefly shape it up for you. As you stated in your brief correctly, experts can testify generally about sexual abuse and some of the characteristics of sexual abuse and some of the reporting issues and the delay and so forth. We said that repeatedly, I think. But we said, on the other hand, you can't tie it to an individual case. And we've got a line of cases, as you know, that kind of cut the salami as to whether you fell over on impermissible vouching or not. But there are a few cases out of the Court of Appeals that you cited that have kind of suggested, well, sometimes this generalized questioning can, quote, amount to a specific vouching when it's, I guess I'll characterize it, when it's kind of generalized questioning that's tailor-made to a specific factual setting. Maybe you've got a better explanation than I've given. But help me, is there a line there, or are the Court of Appeals cases just simply wrong as long as it's generalized vouching? I think you understand the direction I'm heading. Please help me out.
May I?
Go ahead.
In short, I think this court's articulation of the standard in Myers, Dudley, Jaquez, and Brown provides sufficient guidance. Unfortunately, there is a wing of decisions from the Court of Appeals that has strayed from it. And I think so long as the witness, as she did here, makes clear she's not interviewed this witness, she's not opining on this witnesses, as no witness may, on their truthfulness, so long as those protections occur and the testimony relates to children in general, then it's appropriate, notwithstanding the fact that it may tie up rather tightly with what occurred in this case. Because after all, what value is expert testimony if it has little or no bearing to the facts? It's therefore irrelevant. So the tighter the connection between the two, but so long as the expert is discussing matters in general, then I think that's perfectly fine. Some of those decisions, which I list in the brief, ought to be overruled or disavowed. Others could be affirmed or rather endorsed, however you choose. But any and all of the other reasons that I provide, probably clumsily in my brief, we respectfully ask that this court consider and affirm the decision of the district court below. Thank you.
Thank you, Mr. Mullins. Mr. Montgomery, any rebuttal?
You may please the court, counsel. In the Thompson case, the court recognized the intent of the legislature in amending 622 post-Cashin and clearly and unequivocally talked about two sides of that intent coin. One, clearly and unequivocally, is the protection of the confidentiality of counseling records. But the other was, quote, at page 481 of Thompson, quote, while also protecting the due process rights of defendants, end of quote. That's page 481 of this court's decision in Thompson. I think the court said the same in Niederbach. So while we must be very careful to protect the confidentiality, we can't just forget the due process rights. And also, I think it's in Niederbach, the court indicated that the mandate in situations like this is to interpret the statute, in this case 622, so as to not result in constitutional infirmity. So
I'm a little worried about if impeachment alone or a challenge to credibility alone is enough to get access, at least for an in-camera review of somebody's mental health records, have we opened the door too broadly, or should we write very narrowly? I think you've got a good record here that it's exculpatory, but what's the limiting principle? Just because you can ding somebody's truthfulness or credibility, does that mean that the court has to look at the victim's mental health records?
I don't think the court has gone too broad and is going too broad, Your Honor. In Niederbach, the court said, while the term reasonable probability in the statute requires a showing more than the mere fact that mental health records of a witness or accuser exists, all that is required is some plausible theory founded on demonstrable facts that suggest the information in the records might well prove helpful to the defense. In Thompson, the Honorable Chief Justice Cady talked about the fact of the case, and Justice Cady said the standard for judicial review of confidential records under 622.10 should be given its definition through the application of facts on a case-by-case basis, as this case, Thompson and Niederbach, illustrate, Justice Cady said. The facts are what should breathe meaning into the reasonable probability standard, and this standard will continue to gain greater clarity in the future. We think it's in good hands with our Iowa District Court judges based on the promulgations this court has made. Just like the in-camera review is in good hands, we think the case-by-case analysis is in good hand. With respect, we think the Poweshiek County District Court got it wrong in this case. We asked the court to consider looking at how expansive and extensive this offer of proof record is. It was very, very, very difficult for me to be giving that information out. And I think that did impinge on Mr. Leedom's rights, as it required me to tip my hat on how I would cross-examine the accuser against him. And we think that is unfair, and we asked the court respectfully to consider that although we acknowledge at this stage an ex parte hearing may not be necessary in this case, we believe it's necessary for the court to provide the same kind of state ex parte framework in 622 cases as it does in the appointment of counsel cases. Also, we have to, even when the court finds exculpatory, I think it still has to make a balancing. That's important in this case. So it's easier, we suggest in this case. By the way, we suggest to your honors that this case is as strong or stronger for a review of the records than in Niederbach or Thompson or Barrett or Eduardo. That's our respective view. We ask you to consider that.
Should we take a look at U.S. Supreme Court precedent in applying Brady that has appeared to move away from a distinction between impeachment and exculpatory and not try to separate those?
Well, in interpreting the statute, we still have to interpret it so there's not constitutional infirmity as it pertains to the Iowa State Constitution and as it pertains to the federal Constitution. So I think interpretation by the United States Supreme Court is very relevant in this case, Your Honor. We are comfortable with a conditional affirmance, and we are comfortable if upon review it makes mention of the report of sexual assault by Grandpa Leedom, and it comports generally with what her testimony was at trial, then the conditional affirmance should be such that it is affirmed. But if there's no mention in there, direction should be to the court to consider the granting of a new trial, and that's what we ask the court to do in this case. Thank you, Your Honor.
Thank you. The case of State versus Leedom is now submitted, and we're ready for the second case, Rowland versus Annette Holdings.